Need for pro bono and the impact. And as I was thinking of my remarks this morning when I woke up at 5:30 and got into the shower, my hot water heater broke. And there was nothing worse than having to take a cold shower at 5:30 in the morning. And to me, it's a minor inconvenience. To all of us, it's a minor inconvenience. But to the people at AOM, many of them never have hot water. They have to live with that every day. And that really speaks volumes about the importance of what we do to help people, whether it's to get repairs for their homes through warranty of habitability measures, or helping people from being evicted and having to live on the streets and maybe not even having a shower. And why do we do this? We do it because it's part of our obligation as lawyers for our Rule 6.1 of the Rules of Professional Conduct that talk about our obligations to help others who are less fortunate. And we do it through pro bono efforts, and pro bono is helping people who absolutely cannot afford an attorney. So we ask that you honor your professional obligations, which you are doing, and that you really have a good time doing it. One of the things that Volunteer Lawyers does, and I don't know if Henry National explained it to you, but while you're over at AOM, you may be saying, oh my God, what if I make a mistake? What's going to happen to my malpractice? Well, we cover your malpractice, you are covered, and you won't make a mistake, so you'll be fine. The other thing is, do I get something in return other than feeling good? Well, feeling good is really pretty much the primary reason why you should do this, because it does feel good to help someone who can't help themselves. But we also give you free CLE credit, so for every 2 hours that you volunteer, you get 1 CLE credit. You can count up to 10 pro bono CLE credits in a reporting period. But if you're a newly admitted attorney, you can't do that until your second biennial reporting period, but you can carry over 6.
VLP was created in the early 1980s by the Bar Association and Neighborhood Legal Services came together to create it. And we have a dual mission. First, just like Neighborhood Legal Services, to provide quality free legal services for low-income people. We also represent smaller not-for-profit groups too. But the real reason that VLP was created, instead of just making NLS bigger, was the second one, to effectively involve volunteers in the delivery of those services. And so, in many ways, the efforts that all of you are doing or about to embark upon are really the reasons why VLP even exists. There is a statewide permanent commission on access to justice issues that former Chief Judge Lippman created, and they've been doing hearings and studies and doing reports for the last several years. They've been able to conclude that 35% of all New Yorkers live below 200% of the poverty line. And only 31% of the need for civil legal services for low-income people are being met. That's a shocking number, but it's actually a big improvement. About 15 years ago, the state State Bar did a legal needs study, and at that point, it was about 20% of the need was being met. So we're making progress. Still a long ways to go. Here in Buffalo, we've all seen Buffalo. There's terrible information about Buffalo, third poorest large city in the nation. This is one of the things that's really shocking to me. Almost half of all of the kids in Buffalo live in poverty. We're very involved with the Say Yes Foundation, and we've got clinics right in 6 schools to provide legal help to the families. And this is a slide that we always use when we're talking about the reason for the Say Yes clinics, but it really applies to the reason why we're at Buffalo City Court doing AOM. This is a quote from the Syracuse mayor at one of those hearings that the Chief Judge held a few years ago. And she was saying, how is a child expected to do homework if they don't have a home? How can a child learn when they're worrying about where they're going to sleep that night? I've got kids who are teenagers. I know that when there's something that is upsetting them, even if they're not talking about it, it affects their behavior, their performance in school in all different kinds of ways. So AOM was created in 1990, and at that point there was talk in the state about the possibility of mandatory pro bono. Got sidetracked because the state bar and local bars really stepped up and agreed to do more. With local bar, Erie County created a pro bono task force, and in doing their research, they looked at eviction cases in Buffalo City Court. And at that point, there was very little representation going on in evictions. The court itself estimated that over 90% of the unrepresented tenants who were showing up there, which was the vast majority of them, were being evicted with an immediate warrant of eviction and a full money judgment. Exactly, everything that the landlord was asking for. And so that led to the creation of the Attorney in the Morning program. And so now, these are statistics from last year. We represented 1,082 clients at AOM in 2015. You can see this last entry over here is for an immediate warrant of eviction and a full money judgment. What the court said used to be 90%. And last year, this is the first time this ever happened. It's always been a low number. The number was 0. This is the biggest one. This is delaying the eviction and having dollar savings to the client. And you can see that's well over 500 of the cases, well over half. Preventing the eviction, either by getting the case dismissed or more often by coming to an agreement with the landlord. And just dollar savings to the client and then just delaying the eviction and then referring the cases to NLS for more complex cases. So you may be thinking, well, that sounds great, but how do we, we're going to have to go in front of the judge and argue all these cases, and how are we going to do that? 74% of the cases settle in the hallway by stipulation for us. 74%. And almost 10% are people that we talked to and because of strategic reasons decided not to appear. And you're going to hear more about that. So we're almost at 85% of the cases. And then almost 5% go to NLS, and then 12% only are ones where there was any kind of hearing, and that usually is a very brief interaction. So, it's really a system that's designed to settle the cases. The State Bar recognized the Bar Association of Erie County for the VLP program. They're one of our parent organizations with an award of merit, and AOM has been copied in many cities across the country. Now, I also need to talk to you about some limited scope ethics issues, because one of the things that law firms worry about with these limited scope programs where they're seeing a number of clients really quickly is, what about conflicts? Quickly, just make sure everybody knows what these are. 1.6 is the duty of confidentiality. We have to keep what clients tell us, we have to keep secret. 1.7 is about conflicts of interest for current clients, where if they have differing interests, we have to worry about 1.7, very, very high standard, just only differing interest. 1.8 is about specific conflict rules, mostly about conflicts between the lawyer themselves and the client. 1.9 is duties to former clients, where it comes into play if it's the same or substantially related matter and the interests are materially adverse. So it's pretty hard to meet that threshold. 1.10 is important for law firms, imputation of the conflicts to the rest of the members of the firm. If one person has a conflict, the whole firm has to worry about conflict rules. And then 5.1 is just about the duty within the firm to make sure that the lawyers are following the rules. So that leads us to 6.5, which is a rule that the ABA added to the model rules of professional responsibility in New York many years ago now has adopted. And this is specifically about these limited scope programs where the program is run by a court, a government agency, bar association, or not-for-profit legal services program, that's us, and they're providing short-term, limited legal services with no expectation that it's going to continue. This is, really the heart of it right here. When you're over at AOM, you're in a program like that, and you shall comply with rules 1.7, duties to current clients, 1.8, special conflict rules, 1.9, duties to former clients, only if the lawyer has actual knowledge at the time of the conflict. And what this means is you don't have to do a conflicts check. Only if you're in your own mind, you know there's a conflict. Do you have to worry about those rules? And then same thing applies to 1.10, only if you know that one of the other lawyers in the firm has a conflict, you have to worry about it. Also, just to know, services have to be free of charge, and again, with no expectation it's going to continue, and there has to be informed consent by the client. They understand that it's limited scope. Jocelyn takes care of that before the client ever gets to you. But even with all that, if the court decides there's a conflict, or if you become aware during the representation that there's a possibility of a conflict, then the conflict rules kick back in. We take the view that if the lawyer says there's a conflict, there's a conflict. So the rules don't say what happens when you come back to your law firm and you find out, or you don't find out, do you have to do anything to find out for the future if you have a conflict with your attorney in the morning client. And so I wrote for an opinion from the New York State Bar Association Committee on Professional Ethics, and it's opinion 1012. And there was really two questions. One is for the individual lawyer who was there, once they go back to their law firm, what standard applies then for looking at conflicts between their limited scope client and future clients that they might be representing? And the second one is, what about the whole law firm and imputation? First, without our even asking the question, the Committee on Professional Ethics, said flat out that limited scope representation does not require the lawyer or the firm to enter the limited scope relationship into the firm's conflict checking system. So please don't come back and enter those clients. We anticipate that you will come back with nothing about the client. The opinion is great. The participating lawyer remains subject only to the relaxed conflict provisions of Rule 6.5. So it's the same standard once you come back. Only if you're back here and you know that the client who comes in to see you 2 weeks later has a conflict with that attorney in the morning client. And then the same thing, Rule 1.10, even if, let's say Henry was at attorney in the morning and he comes back and he's been really diligent and he got the case dismissed at attorney in the morning, and the landlord comes in now to hire Henry so that he'll do it right and get that tenant out. And Henry remembers the case, he might be precluded from representing that client now, a new client, in that eviction case. But it will not preclude members of the firm, even if Henry is precluded. So someone else from the firm could represent that client. And the same reasoning applies if Henry comes back and finds out that that landlord is already being represented by somebody else in the firm. It doesn't interfere with his ongoing relationships, but nothing about the nature of Rule 6.5 changes the duty of confidentiality. So even though someone else at the firm might be representing that landlord, Henry and that lawyer can't be sharing confidential information. So just in summary, actual knowledge of the conflict is required before you even have to worry about the conflict rules. And if there is a conflict for the AOM lawyer, it's not imputed to others in the firm, but the duties of confidentiality remain.
I handle attorney of the morning stuff, landlord-tenant proceedings. I handle small claims court proceedings. I handle mandatory arbitration, no-fault proceedings. Some of you may or may not be involved with that. Some of the defense work that you do. I'm also in surrogates court and ADR, where I handle settlements in civil cases, things like that. So I'll focus mostly on landlord-tenant because that's, I think, the majority of what we're discussing today. It's very important. You know, VLP, Neighborhood Legal, provides an invaluable service not only to the court system, but to the litigants that are often in these proceedings. You know, it's probably one of the most stressful situations you can face is the potential of being evicted from your home. And you oftentimes, if you can't afford to pay your rent, you can't afford an attorney. And so when you're provided with someone who can help you, I mean, when you serve as an attorney in the morning, I mean, you are really viewed in a high esteem by the person you're representing, because you're the person standing between them and being out on the street with their children, with a sick relative, with a parent, you know, something like that. So, you know, it's really a place where the rubber meets the road as far as like real legal practice and real legal work. What you do there truly affects someone's life. It's not just money, it's not an insurance company, it's real life. So it's very important work. As the court, you know, our job and our goal is to be as fair as possible. We do that with a slight consideration for trying to help make the transition for a tenant or respondent as easy and as seamless as possible. And you guys, if you volunteer as attorney in the morning, play an intricate role in that. You know, oftentimes when you come in, you don't have a good defense because you just didn't pay your rent, or there was proper notice given for a holdover where rent isn't the issue and they just want to remove the tenant from the premises. So one of the best things that you can do for your client is negotiate. And typically 9 times out of 10, what you need to negotiate is for time. Now, one of the things you can do to get them time is you can use your leverage. And based on your agenda here, you're going to learn about defenses and issues like habitability, things like that, which you can use as leverage. Service issues, whether or not service was done properly. You know, landlord-tenant is a very technical area of the law. You have to follow various proceedings. There are deadlines. There are things you have to do the right way. These things can all be used as leverage when you're negotiating. One of the things you have to be careful of, you know, sometimes you go in and you see a defense that might work and it may win a case for your client. And you may think that's the best route to go. But in reality, you may dismiss a case that can be brought and be back in court again, you know, a short time later. You know, someone can just refile an action, and if it's a landlord who has to spend extra money and extra time and extra maybe attorney's fees because they hired an attorney, they're going to be less inclined to negotiate the second time around, and you actually may end up getting a worse deal for your client than had you tried to work out some sort of stipulation. So it's really important to kind of determine what your goal is when you're in there. You have to determine what's in the best interest of your client, which doesn't always mean getting the case thrown out. It means, all right, have you located another place to live? Are you in the process of doing that? You know, you have to ask your clients, there are services available. If they're a veteran, they may be able to go to the Veterans Outreach Center. They have money available. They have services where they can find them an alternative apartment. They have moving services. So you really want to kind of be all-encompassing when you're talking to folks, just to find out what exactly their needs are, what resources may be available to them, and then you can use that sort of as a tool. Worst case scenario, if you can't negotiate a settlement or a resolution, you have to go to a hearing, and that's kind of where I come in. Court can oftentimes be persuasive to let a settlement go through that may not be working out in the hall. You know, people sit in that chair, they realize what's about to happen, and the gravity of their situation kind of hits them, and they become oftentimes a lot more realistic and a lot more malleable in what they're willing to take as far as a deal. So make sure if you're in that scenario, you don't have a problem with coming in, talking to me or whoever's there, and just say, can I bring this case into you? Can you talk to the client? Can you try and, you know, get this one over the top? Because that's one of the main things that we do there. When you have a client like that, don't hesitate to come in and bring them in. Worst case scenario, I can't get it done and you can't get it done, we go to a hearing, okay? Now, this is where more of your leverage comes in. A lot of times when you're in landlord-tenant, if you have a landlord that has an attorney, they oftentimes just send the attorney and they don't go themselves, okay? So if you're actually going to a hearing, you have to put on proof, okay? It's basically a trial, right? So you have to have proof, you have to have it in admissible form, you have to have witnesses that can get it in. And so if you have a client that's there and gonna testify, and the attorney on the other side does not, how are they gonna get their proof in, okay? And so if they're being unrealistic, that's a little bit of leverage you can use against them to get a deal done. And I oftentimes, or whichever referee is there, will oftentimes use that leverage, and I'll turn to them and I'll say, well, where's your client? With that in the back of your head, 9 times out of 10, what a landlord's attorney or what a landlord wants is they want the warrant. They just want the warrant so they can go to the marshal's office, so the marshal can serve, and they know they're getting the property back. And the reason that they want that is because 9 times out of 10, they know that the tenant isn't going to have money so that a judgment that they get is going to be collectible. If you can't pay your rent, you're probably not paying a judgment. So that's the ultimate sort of elephant in the room in landlord-tenant, is that the landlords want the warrant, the tenants want more time. Now, if you're actually in a hearing, if we actually run a hearing, again, it's what do you have? What's your proof? What's admissible, right? 9 times out of 10, it's going to be just your client testifying. They may tell you that they've got habitability stuff, but what you'll learn is when you get into more detail on this stuff later today, things like habitability, that's like serious issues with a property. That's like your heat doesn't work, your water doesn't work, your toilet doesn't work. It's not there's a crack in the window or the door sticks or there's a hole in the drywall or something like that. It literally has to be basically unlivable. Well, the other problem with habitability on offenses when you go to a hearing is it's our job to figure out, one, whether or not something is a habitability issue, and two, what's the value you assign to that issue. So if you say, well, I've got some roaches in the kitchen, well, did you call an exterminator? Did you get a quote? How am I supposed to know? If you owe $2,000 in rent, paying $300 to an exterminator is still not going to get you where you need to be to avoid an eviction. So you have to be real with your clients when you're talking to them, and you have to kind of get a good nose to sniff out, whether or not you have a shot at succeeding on something and how you can use it as leverage. The other issue with habitability is, you have to make sure that you have the money in escrow or the money with you that you owe for the rent to show that you actually held it out because of the habitability issue. You can't just throw it out there and say this is the issue without having it. So those are tools you can use when you're dealing with both your client and a landlord as trying to use the leverage. So as you go through the hearing, it's not quite a trial. We don't really use opening statements, closing statements. It's more just we swear everybody in. Petitioner goes first, provides the proof. Usually it's just testimony. We had a lease or we had an oral agreement. The rent was X, the address was this. They didn't pay. It's for this many months. Blah blah blah. You're entitled to make any defenses, any motions to dismiss, anything before we start the hearing. It's just like trial in that respect. If you have some actual defenses, like improper service or whatever, you make that before, and we'll make the determination whether or not we should dismiss it. Otherwise, we proceed. Once the petitioner puts on their proof, you are entitled to cross-examine them, and then if you decide not to, or if once you finish up, then it's your turn to put your proof on, okay? And usually it's just testimony, but if you have real evidence, I can't stress the importance of actually bringing photographs or bringing bills or bringing receipts for payments that you made to fix up the apartment, because that gives me and the other referees something to actually kind of latch onto, and that can help. Worst case scenario, even if they're going to get evicted, it can help if the rent's $1,000 but they spent $800 trying to fix these problems. It lowers any judgment that they get to $200. So you did help your client in that respect. You may not have avoided the eviction, but you helped your client. Evidence that in small claims, it's the same deal, okay? You gotta, you always have to think about what do I have to prove or what can I prove and how do you do it? When you're all done, we finish up the trial. You can do a brief closing, you can do a very, kind of just summary outline of why you think something should happen a certain way. 9 times out of 10, we'll reserve decision. You also want to get to know who you're dealing with when you're in court. You want to know your adversary, you want to know the court. Everyone's got a different personality, everyone has a different style. Certain things work with some people, certain things work with another. So you want to take a minute maybe to sort of familiarize yourself with who's working, You know, Jocelyn's there all the time for VLP. She knows all the players. She knows everybody there. The only other thing I would encourage is when you're there, you know, a lot of times you haven't dealt with the stuff or you're relatively new to it. Try not to get overwhelmed. You know, you're going to get stories from your clients and they're going to want to tell you literally everything that's going on in their life. And you want to kind of try and box them into what's going on in this proceeding. What do we have? What are our actual defenses? And so it's like a practical concern that you wouldn't normally think of, but you know, sometimes you're just so overwhelmed by the numbers that you can't spend 30 minutes with each client. It's just not doable. You know, there are a few questions you should just ask automatically. You talk with someone. Did you pay the rent? No. Can you pay the rent? No. Do you have a place to go? No. How much time do you think you need to get a place to go? You know, do you have someone you can call, a family member? Have you talked to social services? You want to just kind of boom, 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 boom. It's difficult sometimes as attorneys to sort of rein your client in, but it's important because not only does it help you get to the heart of the matter, but it'll help you be more efficient in resolving the cases, and then it'll help everything move fast. It's important to try to be, I think, as efficient as possible and move cases along as much as possible.
So just a few of the things I'm going to touch on today. Similarities and differences between MLS and VLP. We're a lot more similar than we are different. We both represent low-income tenants facing eviction at Buffalo City Court. We either prevent or delay eviction by reaching agreement or arguing the case before the court a majority of the time. And the actual representation of the tenant is exactly the same. So we're doing the same exact thing when we actually represent the tenant, whether you are there on a VLP day or on a neighborhood legal services day. The differences, main differences, so neighborhood legal services is there Tuesdays and Thursdays, as Bob explained. VLP is there Monday, Wednesdays, and Fridays. One of the biggest differences is that neighborhood legal services does handle all the Section 8 or public and subsidized housing cases because we are full-time staff, we are trained in this, and we're not limited scope. Volunteer Lawyers Project is limited scope and does not handle those tenancies. So the clerks do a pretty good job of screening out those cases and placing them and scheduling them for Tuesdays and Thursdays already when the landlord comes to file. How they get through is that the landlord doesn't actually identify that the tenancy is Section 8 on the court papers, which is a requirement, but a lot of times they don't. So if they don't identify it to the court doesn't know to schedule it on that day. So you may see a subsidized tenancy or a Section 8 tenancy if that case cannot be resolved or if there's issues that are way beyond what we talk about today, or Jocelyn can help you with what exactly, when we need to refer. Those cases would be adjourned to a neighborhood legal services day and referred to neighborhood legal services. Procedure is that all the tenants will sign in with the clerk and then they'll call the cases from that list and then you'll be assigned a client from there. So neighborhood legal services in 2015 represented 1,897 tenants, and last year 1,293 tenants at Buffalo City Court. There's two types of eviction cases: non-payment and holdover. Non-payment, self-explanatory. Holdover essentially means any other type of eviction besides not paying your rent. There's a lot of different types of evictions that have nothing to do with a tenant not paying their rent. So the majority of cases at Attorney of the Morning are non-payment. They're generally resolved in one of two ways. Either the tenant pays and stays in a negotiation, or sometimes they'll pay and stay in a hearing. So sometimes the landlord doesn't really want the tenant to stay, but the tenant shows up with all of the money that's owed. And that could be a potential defense that you go to a hearing and they actually get to stay because they pay all the rent. In a holdover, it's not as common, but I say that we do see these cases regularly. What that means is the number of cases you'll see, majority will be non-payment, but you will see holdovers. So probably every time that you're volunteering, you'll see a holdover, or once every second time. They almost always resolve with the tenant moving, unless you get the petition dismissed, because it's not an issue of paying, it's some other issue. The very first thing when you're there for non-payment eviction, does the client want to stay or move? You have to ask this question first, because, as I learned the hard way when I first started, if you wait till you get into the story, you may get halfway through, you spent 10 minutes talking to the client, you think because of everything they're telling you, they want to stay. And then you get into it, you're getting into their defenses, you're all prepared, and they say, well, I can be out this weekend. And you just wasted all that time, you wasted their time, and you can represent somebody else. If they're gonna be out this weekend, that's a pretty easy settlement. So ask whether they wanna stay or go. That'll save you some time, and that'll also inform what questions you need to ask. So when was the tenant served? So it must be between 5 and 12 days from the court date. So you have to check service that they received their court papers at least 5 days ago. Usually that is what you'll see over there. You don't usually see that it's been more than 12 days. How was the tenant served? 3 ways. So they can be personally served. They can be served to somebody else at the household who's of suitable age or discretion, does not have to be another adult. So sometimes you'll have a client that says, my son was served. Okay, how old is your son? 16. What does your son look like? No, if the son looks like somebody of suitable age and discretion, that won't be a defense. And nail and mail. So nail and mail, you might be familiar, but basically they'll post the petition, notice of petition and petition to the door, follow up with regular mail and certified mail. What you'll see a lot of times, you'll ask for the client to give you their court papers and there's tape on it. You can pretty much assume, but you always ask that did they get them on their door? And always follow up with, did you get them in the mail? So I don't usually say, well, did you get a certified mail copy? Because a lot of times, the post office will post the little sticky note that says, you have certified mail to pick up if they are not home. And they might not ever go to the post office to pick that up. That is not a defense. Because they didn't pick up their petition, it's not a defense. It's whether the landlord actually sent it certified mail. So as long as the landlord sent it, how you're gonna find that out is through the clerk. The clerk will have the disposition sheet, which is the sheet that shows how service was done, and a proof of the affidavit of service attached. So is the affidavit of service complete? You're going to check the description. If personal, you'll be shocked to see personal affidavits of service for personal service that don't have any description. So, date of mailing, again, you'd be shocked to see how many don't even say when they allegedly mailed service. And attach the certified mail receipt. Is the owner or owner's attorney present? So only an attorney can represent an owner, even if they're married. So unless both parties are on the deed. So a lot of times you'll see an aunt, a sister, a parent, a son, all sorts of family members, somebody with power of attorney. They cannot represent in a summary proceeding. So if it is not the owner of the property who is there, it has to be an attorney. And if it's not an attorney that you're dealing with, you want to make sure that it is the owner, one, by asking the tenant if they know this person. Sometimes the tenant doesn't know the person because the owner of the property and the manager are different. They deal with the manager, they never deal with the owner. So another way that you can check on that is to call the Buffalo Assessor's Office. When you call right from court, they are very easy to talk to. They don't even need to know where you're calling from. You just say, I'm calling to get ownership on this property. They'll say, what's the address? You say the address, and they'll give you the owner's name. You can do that quickly from court if there is any questions about ownership. The court can also look it up. So if there is an issue, you can talk to the clerk to see if they can look it up for you. Does the petition include information regarding subsidized status? You will not be handling, most likely, subsidized cases unless the tenant is moving or there's some issue that can be easily resolved, but generally they get adjourned. Is the tenant in possession of the apartment? A lot of times you'll see a tenant who says, I'm out, I moved, I'm not even there anymore. Well, that's great, but did they turn over the keys? That's the first question you have to ask, because if they didn't turn over the keys, they haven't actually given up possession. In their minds they have, they've moved, the landlord doesn't know that they moved. Sometimes then you say, did you tell the landlord? No, but I've been out a week. Well, okay, but we still have to resolve that. Now, of course, if they have given up possession, that would be a defense because the whole reason you're there is for the landlord to gain possession. So that is actually a defense to the summary proceeding. But if they haven't turned over their keys, or if they say, well, everything's out except for I left the couch, or I have this, that, and the other thing in the apartment, they haven't given up possession. But if they essentially in their minds have moved, it should be an easy negotiation because they don't want to stay there. So, is the petitioner demanding monies other than rent? So the first thing you want to check is there a lease? The reason is, if there is a lease that actually provides for other things other than rent as additional rent, then the landlord will be able to demand those monies in summary proceedings. However, if there is not a lease, they will not. What I tell everybody is, in a negotiation, and which is mostly what you're going to be doing, landlord can ask for whatever they want. They can ask for $1 million, you're going to say no, there's no deal. So they can ask for attorney's fees, they can ask for the water bill, they can ask for whatever they want in negotiations. That's where your leverage comes in, that's where the negotiation part comes in. However, once you're before the court, they're not going to be able to get those things unless they are provided for in the lease. So keep that in mind, because I think a lot of newer attorneys think, aha, they don't have a lease or the attorney fees are not in the lease. They can still ask for those, however, in a negotiation, because you are negotiating. So what you're looking for, especially if you're going before the court, is it has to be in the lease that it actually says that any other fees or attorney fees or whatever is at issue is considered or is deemed additional rent. Because if it's in there but it doesn't say that it's additional rent, it cannot be demanded in summary proceedings. So that's not going to be an issue. So for instance, the biggest time that you'll see this where it's important is your client owes 1 month's rent, $500. Comes with $500, maybe comes with a little extra for the filing fee, which we'll get to. But so they come with the money, but they don't have the $300 for attorney's fees. You still have a defense if that's not in the lease and provided for as additional rent, because that is not then something that the court can consider. So then the court can only consider the rent and not the attorney's fees if it's not provided for as additional rent in the lease. So non-rent charges have to be actually included as additional rent.
Let's say that the client doesn't have the lease, nor does the landlord. So what do you do then if that's the situation?
First situation obviously is asking the other side so that you can see. If they can't provide that, then you have an issue, and that would be an issue to bring out to the court, and it's the landlord's burden. So the landlord has the burden to prove that it is provided. If they don't have the lease with them, more often than not, the judge will say, well, then we can't consider that today. So is the amount due in period for which rent is due, or for which rent is owed clearly stated? So sometimes you'll see a petition and it'll say the tenant owes, not in this language, but the tenant owes $1,000, and that's it. That is not acceptable. They have to break it down. They have to say March 500, April 500. And that is to prepare a defense, of course. So the tenant needs to know, what are you charging me for, because I actually have my receipts for March and April. And then you get into sometimes that maybe they were behind in February. So what they paid in March went to February, and what they paid in April, and so forth. So it does need to be clearly stated in the petition. So sometimes landlords will try and argue that it's not in the petition, but I attached a ledger. Well, that would be up to the judge, but our position is that it has to be clearly stated in the petition under the RP appeal. Did petitioner demand rent prior to commencing action? So one of the requirements for a non-payment proceeding is that the landlord has to do what's called a pay or quit demand, or a pay or quit notice, but that does not have to necessarily be in writing. So they have to give what's called a 3-day notice, because they give the tenant 3 days to pay before they take them to court. Generally, it's orally or in writing. If it is in writing, it has to be properly served. So if it is in writing, it still has to be served the same way as a petition, so personally, substitute, service, or mail and mail. And it has to be after the 1st. So if rent is due on the 1st, if the landlord says, where's your rent? I don't have it, and then on the 2nd they file their petition, that is not okay. Or even on the 1st, they demand the rent, 3 days later they file, that's not okay because it's not late yet. It has to be at least, if rent's due on the 1st and it's not late until the 2nd, then that's when the pay or quit needs to be served. So the second type of eviction is holdovers. Now, in general, holdovers will take a little bit more of your time, a little bit more of your limited time over there. Because there's a lot of facts going on, and a lot of the holdovers, there will be some legal defenses, and sometimes there'll be factual defenses. So first, you have to check the termination notice. It must be clear and unequivocal. If you see this notice, and you clearly know, haha, this is not a good notice, I can get this dismissed, but the tenant says, I'll be out in a week, they already talked to me about it, I know that they want the apartment back. You gotta remember that you're doing what's best for your client. So if your client just needs time, you can use that as leverage. You can say to the landlord, go to the landlord, will you give them an extra week? No, I want them out immediately. Well, I can get it dismissed now, and now you're gonna have to start all over with the proper notice. You're not gonna be in here for another month. And that's what the referee would do as well. If the landlord's being unreasonable, that's a case where you would bring them into the referee. If they're being unreasonable, you know you can get it dismissed, but you also know your tenant only needs an extra week. And that's something, a conversation you would have with your client. You would say, I believe I could get this dismissed with this defense. It's up to you. However, if it gets dismissed and you're not out, you could be brought back. Or we could come up with a date that you would be out, and then nobody else you don't have to worry about coming back. So that's a conversation you would have. So in some circumstances, you would just get it dismissed. That would be the best for your client. But in some circumstances, maybe there's some other provision that your client wants that you can get into a stipulation because you have that leverage. Also, the termination notice has to cite the lease provisions violated. So, if there's a lease. So let's go back. If there is a lease and it's not the end of the lease, it's the middle of the lease, and the landlord is bringing the tenant to court to get possession because they say that they violated their lease. You have to cite the lease provision. You must leave by October 15th because you violated your lease by having decorations on your door. How does that violate your lease? Did they attach the lease? All of that. So essentially what you have to look for is the landlord has to make it so that the tenant can prepare their defense. So did petitioner provide timely notice? Again, is there a lease? So you will see this theme, again, one of the first questions you should be asking, or what you'll already have that information, I believe, from whoever is working up your case before you get it, will be, is there a lease? So if there is a lease, they have to abide by the lease. So if they have a lease that says if they violate the lease, they get 3 days before court, then the notice only has to be 3 days. If their lease says it only has to be 10 days, then they only have to have 10 days. There's a lot of misinformation out there that everybody gets 30 days, everybody gets a month. If they have a lease, the landlord has to abide by whatever the provision is in the lease. And if there isn't a provision, then you default to it must be 1 full calendar month. In a month-to-month tenancy, somebody doesn't have a lease, and the landlord wants them out, they have to be given a full calendar month's notice. If rent is due on the 1st, which most are, then before the 1st, they have to have notice to be out by the end of the next month. So if the landlord wants somebody out in October, they can't give them notice October 5th to be out November 5th and say that's 30-day notice. They don't have a lease. That wouldn't be proper notice. And they can't just wait the time they would have given them to make it be good notice. So for instance, if somebody is giving notice October 28th for November 28th, not good notice, they can't just wait till the 31st or wait till the 1st and file and say, well, I gave them that full calendar month. If the notice doesn't give them that full calendar month, you actually have a defense. And again, summary proceedings are very technical. Is the proceeding premature? Petition must be filed after the effective date of termination notice. Pretty self-explanatory, but that does happen. So landlords sometimes, for whatever reason, get antsy, or a lot of times what you'll see is a landlord will say, so the landlord will give notice to be out by the end of November. However, for whatever reason, the tenant did not pay November rent. Instead of filing a non-payment eviction, the landlord just hurries up and files a holdover in the case and just says to the court they didn't pay their rent. Well, this is a holdover proceeding and you gave them until November 30th to be out. You can't file on the 28th. So that would be a premature holdover eviction. Did petitioner accept rent after the lease termination date but before petition is served? So you can click to the next one and we'll go over that. This is the most common defense you'll see in holdovers, I would say. What wouldn't be sufficient or what would be a legal defense is if they were told to be out on the 31st, they pay their rent on the 2nd, and then on the 3rd, they start the holdover eviction. What happens is we say that the payment of rent vitiates the holdover notice. So that notice is no longer valid, they've restarted the tenancy. What is rent acceptance? That is up to the judge. However, if you look at the case law, obviously cashing the check is acceptance, or taking the money and giving a receipt is acceptance. If they're getting money from social services, for example, and they're not returning it, but they haven't cashed it, we argue that is acceptance. If they haven't returned it back to the tenant, that would be acceptance, because the tenant then would rely on that my rent's been paid, I get to stay. So a lot of times tenants especially will get confused about this point. So they got a notice September 30th or September 28th or anytime in September to be out by the end of October. They don't pay October rent. That's not a defense. They were in the apartment per the notice through the end of October. So if they were given a notice to be out by the end of October, they don't, and they pay October rent, that's what they're supposed to be doing. So that is not a defense. And a lot of times you'll see a tenant say, well, they took my money for, they took my rent and now they still want me out. Well, if it's for the month that still is covered by the notice, that's fine. It's after the expiration of the tenancy. And then also you'll see where they don't pay that month in a non-payment. So somebody might get a holdover notice to be out by the end of October. They don't pay October rent because of that notice, then they get brought to court for a non-payment prior to October 31st. So October 15th, they're in court for a non-payment of October rent, and your tenant is saying, no, they gave me this notice, I have to be out. How can I pay rent and move? Because for 99.9% of our clients, they're not going to be able to afford to pay the current month's rent and move for a security deposit and first concern. So a lot of times that will happen, but that's not a defense. Warranty of habitability can be a little bit complicated. It's not, it goes against common sense, I would say. It's not what you would think it is. And really what it is it covers conditions that affect life, health, or safety. So as John Gorman said, these aren't repairs that need to be made, but that don't affect the way you're using your apartment or potentially your health or your safety. For instance, a door that sticks is not going to affect your life, health, or safety unless it's maybe your front door and it's not secure. That could be a potential where you see it. But if it's a bedroom door or a bathroom door or something like that, it might be a repair that needs to be made that hasn't been made, but it's not going to be warranty of habitability. It's not only conditions such as electric, heat, water, things like that. It could be an extermination issue. A big one we're seeing now is bed bugs. So lead paint is if they have proof, so you'd have to have proof. So if a child is going to the doctor and getting tested, they have high lead levels, and that would be potentially definitely a warranty of habitability. Another thing that you'll hear about a lot are external, so things that are in the exterior of the house. It depends on what it is. If the porch stairs are really in bad repair, that could be a safety issue if you're using the stairs, obviously. But if there's some chipping paint, and even if the city has said that that's a violation, if that's the only violation that owner has is the chipping paint on that exterior of the home, not going to be warranty of habitability. If they can use the rest of the apartment, not just one room, their rent payment is going to be small because it's just the one room. Now, if it's the kitchen, then it probably would be larger because you need to use the kitchen every day. But something that you have to keep in mind with these cases is that if somebody, as John Gorman said, owes $2,000 in rent, if they have one room where the ceiling has, maybe not the whole ceiling has come down, but like some of it, or they have a repair that needs to be done, it's not going to, unless they come with all but $100 of that rent, it's not going to be a defense for them. The judge is going to look at that and say, okay, what percentage of the rent should be reduced because of these conditions? Now, what we always tell tenants is, if the condition of the premises is so bad that the judge would reduce it more than 50% of your entire rent, it's probably too bad for you to stay there. We advise tenants against going on the record and saying how bad these conditions are while they have children. Number one, obviously for CPS concerns, but also the judge is now in the court is on record hearing about these conditions. They can't then give you 2 months to stay there with your children if there's all these horrible, horrible conditions. because then if something happens, there's liability concerns. We always tell people, you know, if it's that bad, how about we work on trying to get you a new place and a safe place to live? Maybe we can get a little bit of time, but if somebody's coming to us, I need 2 months to live, but because I need to save up, but there's, you know, the whole ceiling is falling down. It's not going to happen. So you have to be realistic. And unfortunately, you'll see and you'll hear a lot of stories about people living in conditions that you think people would never live in, especially in these days. But you have to but people get accustomed to, I guess, what they're in. So they know it's bad, but it's better than being in a shelter. It's better than being on the street in their minds. So they'd rather put up with no electric, or hardly any electric, or no heat, than go to a shelter, but they can't in the middle of winter. What do you need to prove that? There's a few ways that it can be proven. Obviously, the best way is if the inspectors have been called or the health department's been out and there's a report. Or even if the report is the gold standard. So if there's a report from the building inspectors or the health department and it reports a condition that would fall under warranty of habitability, that's essentially all you need for proof. Because the judge will take that from the third party, obviously if it's the city inspectors, from the city itself, and that will be enough proof. The last point I think I took from the guidelines was, remember, you and Volunteer Lawyers Project are making the initial appearance for the client. So if it is a frivolous claim, or if you're adjourning it for a warranty of habitability that then nobody's going to represent on because it really doesn't have merit, everybody looks bad. So really keep that in mind, you know, just because the tenant really thinks this was bad and this falls under warranty of habitability, you are the attorney, you're there to advise them whether or not it does. When to refer a case. If you're going to refer a warranty of habitability case to Neighborhood Legal Services, VLP never just refers and says MLS will take this case. So they're not going to say, yes, you will have an attorney for this next hearing if you're referring it to Neighborhood Legal Services. What you say is, you know, contact Legal Services as soon as possible, tell them that you have this case on this day, they will discuss with you whether or not they can help you or whether or not they can assist you. So in order to refer them though, you should know so that you're not referring people that we're not going to be able to help and then they're kind of stuck in the middle. If the client wants to stay, if they don't want to stay, then you should just be negotiating for time while you're there, because putting it off for a hearing really isn't going to help at that point. If they have at least 50% of the rent owed, that's an NLS policy, and that again is for the reason of if the person doesn't have the rent owed, or at least 50% of it, even if they win and they get the abatement and they can't pay whatever the judge says is owed, they're still getting evicted, they're just getting a smaller money judgment against them. In most cases, if the person wants to stay or wants more time, that's not going to help. And if they're willing and able to pay any balance still due after the abatement is taken into account. So if it's absolutely impossible for somebody to get caught up, even if they get their 50% abatement, it's probably not a case that we're going to be able to do a full warranty of habitability hearing on. And that's just because these cases do take time to work up. I mean, you have proof, you have to prove the conditions, you have to prove that the landlord was notified of the conditions and failed to act. And you're going to have to spend more time on working that case up. If it's something that where the tenant is just going to have to move anyways, then it's probably not the best case to refer. Again, when referring to MLS, please make it clear that they should contact us immediately. I would say if possible that day, or definitely the very next morning, because if they wait till the day of court or the day before court, you know, it's much more difficult. Illegal use. Sometimes, and this is definitely not that frequent, that you'll see a case of illegal use. What they usually call it is a body house. But basically that is when the landlord is saying that the tenant is using the apartment for any illegal use, prostitution, illegal trade, usually it's drug manufacturing. The landlord does have the burden of proof to establish the illegality, and he or she must prove the particular use alleged. So the landlord just can't say it or just can't allege it, they do have to prove it like any other case, but it must be continuous. So it can't be a one-time thing, it can't be something minor. Under this provision, it would have to be continuous illegal use. Negotiations. Most of our time is spent there, and it's because they usually result in a better outcome for our tenants. It's not because we think it's quicker, or we don't want to do hearings. It's because usually the tenant is going to get the best deal if they negotiate. Number one, they know what the outcome is, so they're not leaving it up to the judge. They can see on paper, this is what I'm agreeing to, this is what is going to happen, yes, I'm okay with this. So a lot of times that is the best outcome. More often than not, our clients do want to stay, they just need time to do a payment arrangement, to get caught up on the rent, and landlords, a lot of times they just want their rent. It's not anything personal, they need their money. So if we can get that payment arrangement in place and get some protection for the landlord that if they don't make their payment, they can get the warrant of eviction, everybody's happy. For instance, if the tenant's goal is to stay, that's what I said, but if they don't have a defense, then, I mean, if we can negotiate them even an extra week or an extra few days, doesn't seem like a lot, but to somebody that's facing a 3-day eviction, getting them 8 days to move instead of 3 is a win. Just a few tips: don't make promises your client can't keep. Make sure your client has provided you with specific and realistic negotiating parameters. This is a big one in payment arrangements. If you talk to a client or you see from the intake sheet that they're maybe on a limited income of $1,000 a month, and they're saying they're going to pay $2,000 that month, how are they going to do that? And you really need to make sure your client understands that if they don't make this payment, that they will be evicted, and there is no going back and saying, well, this happened or that happened. If they don't make that payment, that's it, they will be evicted. So you have to really keep that realistic approach with the clients to make sure they're not just coming up with a payment arrangement that they know that they can't keep. Always bring any offer made by the landlord back to the tenant. It's pretty standard, but sometimes, so you know that, and you know that just from being an attorney, but when you're at court and it's very chaotic and the landlord says, I'll give them 2 days, 2 extra days, and you're just like, they should get, this should be dismissed, they should at least get a month or something. In the back and forth of all of that, it's sometimes hard to remember, okay, stop, go back to the client, let them know that it is, that they've offered 2 extra days. You need to bring the offers back, you can't just gloss over that. Because you never know, sometimes tenants will surprise you and they'll end up taking a deal that the landlord proposes, even though you think that's completely against what you thought that they wanted, and when you first talked you thought they would never go for that, but you offer it and maybe they'll accept. Also be mindful of the court docket, how many more tenants are waiting to be seen. So we always say, you can't spend 30 minutes with a client, unless you have one client for the day, but depending on how many people are waiting to be seen, sometimes you can spend more time and sometimes you can't. There's such a large docket, you're not going to be able to spend the time going back and forth, back and forth, back and forth. So if you go once or twice, there's no deal, that's the time to bring them in front of John or one of the other referees to see if you can get something when they're sitting in that room. Because they usually will try and get a negotiation done before they go on record for a hearing. And sometimes, again, it does happen. You go out there, you can't get anything done, you go in, and then everybody agrees to what you were talking about in the hall, but now that they're sitting in those chairs facing the court referee, they're willing to agree. The practice has been at Buffalo City Court, even if the tenant is discussing the case with the attorneys in the hallway, and they've signed in with the clerk, that they actually haven't put in an official appearance with the court unless they actually appear before the court referee. If they are there, they're talking to us, and they don't have a defense, the landlord's not willing to agree to anything, you're just kind of stuck. But maybe there's $3,000 alleged as owed, they don't have a defense to that, they're just looking for some time, and they do work, and they aren't judgment proof, that they could actually get a judgment that could garnish their wages. That might be a situation where if they're served nail and mail, they may not want to appear before the court referee. They may want to, what we call, walk. So they might want to not appear, get the default eviction against them, but most likely they will not get a money judgment against them in that scenario. It's just something to be aware of, and you can advise the client. They can make that call. stipulations, the stipulation form is in your materials. That is the form the court has actually come up with. So it's kind of a checkbox system, so it makes it a little easier. So what we say is with payment arrangements, include language, this represents all monies due and owing through usually the end of the month. That kind of avoids some confusion, especially if it's a complicated case with lots of different payments, or if it was a little unclear in the petition what's owed, then you usually want to say what those payments cover. Be mindful of the deadlines. If somebody always gets their check on Fridays, you may want to make the deadlines Mondays so that they can get the money order, get it to the landlord. It has to be in hand. Sometimes people think in terms of their pay period, but they don't think the time it takes to go get a money order, to get it to the landlord and all that. So if the person works till 5, they're not going to be able to get it to the landlord that day. So you got to make it a day or two later. The top one, the agreement constitutes a mutual termination of the tenancy. This is something that lately the referees are doing a lot. It comes out of subsidized housing because it was language that we like to put in subsidized tenancies, but they've been using it for all tenancies. So they've been using it, if you can, to get a mutual termination of the tenancy, just to have some language to show a future landlord if you have to, that everybody agreed to terminate instead of just being evicted. Go on the record, pro se parties, if the landlord's not represented, it needs to go on the record even if you have a stipulation. When you use an interpreter, it's good to put it on the record to make sure that it's on the record that an interpreter was used and that the tenant agrees. And if there's roommates, there could be a conflict of interest with roommates, so you might be only representing one roommate. And so if there's other roommates but everybody agrees, then just have it all on the record so that it's clear that everybody agreed. Day late and dollar short, we always tell everybody all your payments need to be made, can't be late, can't be short, you will be evicted. But you can pay early, you can pay more. Emergency benefits, social services, 478 Main Street. So it's not the RAF building, it's a separate building for emergency benefits. If they owe back rent, they may be able to get social services to help them pay it, but they must have a future ability to pay their rent. Social services isn't going to pay back rent, they're then just going to be evicted next month. Social services can also help with moving and storage assistance. We may not get a parade, but our job is important. People may or may not show their thanks, but at the end of the day, you can go home knowing you did your part to hopefully prevent some people from being homeless. So it's very important, and it might feel like you didn't do a whole lot if, again, you got somebody a little extra time, or you just did a payment agreement that they probably could negotiate themselves, but we really are important, and it is definitely good work that you guys are going to do.
We are attorney of the morning every Monday, Wednesdays, and Fridays. I usually get there around between 9 and 9:15. When I have someone that's new that I schedule, I do get there a little bit earlier just to be able to go over the forms, which are attached to this packet. But I will also go to show you guys what's in our box. We have the forms in there, the stips. I also have what is called a blue binder with also case law information. And we also have a folder that I have labeled resources, which has information about social services, the letter of guarantee, and other places that they can go to get funds to try to help them out, or even try to help them find another apartment in a short amount of time. So once you guys get there, I usually wait in the hallway for the clerk to come in. We're always on the 6th floor, part 14. Once the clerk gets there, we will go inside and wait. The doors open at 9:30, and that's when the clients start to check in. They will check in with the clerk, and the clerk will ask them for their name or their documents, and they will ask them, do you want to talk to volunteer lawyers? Some will say yes, some will say no. If they do say yes, I check them on our list. Once they finish checking in, we go back in the hallway, and that's where we start the intake process. So while we're doing intake, attorneys are more than willing to sit with us just to get a head start to listen to what their issue is, whether they want to stay, make a payment plan, or move. Once we finish the intake, we put the files on the side, and the attorneys will start grabbing the files. I keep 2 separate piles. One pile would be for landlords that have attorneys. Those we try to get out first, and then the other file would be just regular landlords with no attorneys. The attorneys will grab the file, like I said, they'll start the negotiating process, try to get a stip. Once we're done with the intake, we will jump in if they need copies, if they need us to explain something. We jump in to try to keep the files going. Any questions? Henry, you have my email, correct?
I do.
He has my email. You guys can email me. Once I schedule you guys, I will give you guys my cell phone number. If you guys are ever running late, feel free to call me, text me, email, or if you can't make it for whatever reason, do so as well.
Hi, well, I'm Susan. I'm a mother of 5 kids, single mom, work. What can I say about it? Well, the reasons, I live in Buffalo. It's a great, nice area. And the reason why I show up here to court today is because usually, like a lot of you guys out there have problems with your landlords, and money, the way you live in, the way the conditions the apartment are. All that stuff brought me here today, and that's mostly why I'm here. I getting home from work, and there's an eviction notice taped on my door that says I had 30 days to get out. Okay. So I had no idea where this came from. I had no idea what to do, confused, scared. So oh yes, it's a feeling that you can't forget it. It's so nerve-wracking because you really don't know what you're gonna expect. You don't know what's gonna happen, especially when you're coming in by yourself. You don't know anything, so it's really a nerve-wracking feeling. No, not at all. I came in, I waited till they open the doors. We go in, you sign up. They ask you, do you have any legal representative with you? I said, no. They also ask you, will you like someone to help you? I said, of course. He said, they told me to wait outside, and I will have somebody call my name, and they will help me through all that. Okay. I'm going to be real honest. Once they say I will have a representative with me, honestly, it will make you feel way better, because at the beginning you're lost, because you don't know much about rights, legal rights and stuff like that. You feel so nervous and lost, but once you have somebody there that guides you and have the time to sit with you and help you with your problems like they did, you feel so much great. You feel like, I got this, So everything came to an agreement, most likely, but I still feel pretty good because my lawyer was there 100%. Well, what I'm hoping is for the right stuff to happen, which is her, since she took this month for my rent, giving me till the 1st so I could move out. Or fixed was needs to be fixed in order for me to stay.